Good morning. My name is Matthew Lindy. I represent Deborah Cosman, the personal representative of the estate of Wanda Rodriguez. Deborah Cosman is present in the courtroom today. May it please the court, I'd like to reserve 5 minutes, Your Honor. There's a fundamental issue underlying this appeal, and that fundamental issue is what type of evidence is appropriate when dealing with a punitive damage case in front of a jury. And the following phrase from Rinaldi v. Aaron, Florida, 1975, was discussed over and over again in a motion in limine, in briefs, and actually, I believe, at the trial. And in Rinaldi, the court said the following: in determining the amount of punitive damages, the jury may consider the nature, extent, and enormity of the wrong, intent of the party committing it, and all circumstances attending the particular incident, as well as any mitigating circumstances which may operate to reduce, without wholly defeating, such damages, including the financial position of the defendant. Now, a key issue before the trial court, and where we believe the trial court committed a basic error, is determining what that phrase actually means. Does the phrase actually mean that any mitigating evidence, which could be considered mitigating in front of the jury, should be allowed to be presented? Or what we believe that the Supreme Court was saying is that mitigating damages attending to the particular incident. In this case, the particular incident occurred, we believe, on late June 26th or June 27th, 2007, when Joseph Rodriguez murdered his wife while she lay sleeping in a bed, which was a different bedroom from the bedroom he was in. So any evidence that relates to that specific act of murdering his wife while she lay sleeping would be appropriate evidence to put on in front of the jury. What type of evidence could that be? Maybe there was some type of abusive relationship and the wife was abusing the husband. Maybe the husband caught the wife with another man. Maybe the husband had some kind of psychological difficulty that caused him to misperceive reality. But what if there are no evidence like that? What if there is no evidence like that, or they choose not to put on any evidence? What about evidence of a developmentally disabled child, or what we believe to be a developmentally disabled child, living in another state, who had not seen the couple for years, was not anywhere near the murder on June 26th or 27th, 2007, and the claim that punishing the murderer with punitive damages would in fact punish the developmentally disabled child? I would respectfully submit to this court that that is an interpretation of Rinaldi is a question of law, and the trial court committed error in its interpretation, and that affects the standard of review. The normal standard of review, as this court well knows, is an abuse of discretion. But if the court misinterpreted the case, then it's de novo.
To the extent this ties into the jury instruction, help me understand, as I recall the development of the instruction, why isn't this invited error?
Your Honor, could you rephrase the question, please?
The way the instruction developed, why don't we have a situation of invited error?
And which instruction is that, Your Honor?
The instruction that would allow considering, the ruin of the person who would pay punitive damages.
Are you talking? I'm sorry, Your Honor. You're talking about the financial resources?
Yes.
Okay. Originally, the jury instruction was totally appropriate. There's no question.
When were these instructions devised?
To the best of my recollection, Your Honor, there was 2 times. They were dealt with at the beginning of the trial to the best of my recollection. There was no objection to that jury instruction then. There was also, I believe in the trial transcript, there was a time where the judge in briefly passing said, are these instructions okay? I do believe that as trial counsel I said yes. Then they started to read them. I asked for a sidebar conference and went up to the judge before it was read, or right after the jury instruction was read, and said, Your Honor, they have not put on any evidence. So the answer to your question, Your Honor, is that I brought it to the court's attention. Now, what the court's response was is not, it was invited error, Mr. Lindy, it's too late. The jury was right there. It could have given a curative instruction. The court's response was, and I just believe this was the error in that specific issue, is that the court said they put on evidence. That's what the court's reasoning was. We have scoured this trial transcript, and I can't find any evidence at all. So the answer to your question, Your Honor, is that you could say it was invited if there was nothing the trial court could do. The trial court could have easily given a curative instruction. But the trial court said they put on the evidence. That is error in that specific issue, because they could have done it and said there was no evidence. I don't know. The only evidence we did see was some mention of a house, but if you look at that entire transcript, you're going to not be able to figure out who owns it, because there were some issues about the estate owning the house. There were some issues about does the defendant own the house, and that's it, nothing else. The jury was given an instruction that you may not financially bankrupt the defendant. And I believe this jury was sincere. They wanted to do the right thing with what they were told. But if you're given that instruction and you don't have any idea what they have, how could you actually award anything? Because any amount of money could financially bankrupt the defendant. So I believe that in and of itself, the jury instruction was error. And that by itself would require a new trial. The trial started out by putting on Joseph Rodriguez. And the question here is, what should the trial court have done when, as trial counsel, I requested that the trial court allow me to voir dire the witness to determine if the witness had capacity? The trial court's response was, to paraphrase, I'm not sure it's exact, we're not going to go there, let's go. Now, under the cases that I've cited in the brief and the reply brief, the trial court should have made findings of fact. The trial court cannot make findings of fact if all the trial court does, and I agree with Mr. Donnelly, the trial court is in the best decision to make that determination. But I would submit to this court that that determination is not something you make based on what was said, a desire to move quickly. If you look at the 57 pages of the reply brief that the defendant submitted to this court, you will search in vain for an actual quote of what Albert Rodriguez said. Well, it's on pages 170 through 173 of the trial transcript, and on pages 12 of the initial brief. And if you look at what he actually said, it's incoherent.
To what extent was your ability compromised to show what you consider to be his incompetency to testify?
I believe that that caused several problems. Number one of the issues was whether Albert Rodriguez was represented in the probate. Now, I would submit that that whole issue isn't relevant, but the specific question to him was, aren't you represented, I believe the specific question, aren't you represented by Stephen Buckley? And his answer was, I don't know who that is. We gave him, whenever you have in a probate, you have there was a second will here, and somebody wants to be personal representative. Under the probate code rules 5201B, you are required to submit via certified mail notice that you're applying to be the personal representative to everybody who's got equal or greater priority. Albert Rodriguez signed the certified mail receipt. We gave it to him and had his signature on it, the actual original receipt, and he couldn't understand what it was. So those two, and was Albert a beneficiary of the will? Albert, he's a nice kid, a nice guy. He's actually older than me, but he couldn't decipher whether he was a beneficiary of the will. We asked him because before we came in, we could hear, because Albert was talking too loud. He didn't know he was supposed to be quiet, but right before the trial resumed after lunch, we could hear him down the hall. I asked him, and it's in the transcript, didn't you just meet with Mr. Donnelly right before coming in here? And if you look at what he actually said, it's incoherent. He said, who is that? I don't know, I don't know. And so, Your Honor, the answer to that question is, I don't believe he had the ability to comprehend and answer the questions.
Well, it sounds like perhaps he did not answer any questions. So maybe that helps you.
Your Honor, it could be, but I would submit that it didn't help, because I would submit if you look at the last instruction, if you look at the closing argument, the closing argument was not something about, look, jury, Joseph and Wanda got along. I don't know how that would be relevant anyway. The closing argument was, and I think this is very important, is that, but in this case, if punitive damages were to be awarded, who would be punished? That's a question to the jury. Who would be punished? And who would suffer? Does the son have to pay for the sins of the father? Again, I think this was a good jury. I think they wanted to do the right thing. But you've got this person up there who, by any imagination, is looking very pathetic and he needs help. One of the jury questions was, does Albert, the question I paraphrased was, does he have Alzheimer's disease? So now what the jury's thinking about, and I believe that the reason he was put up there was to elicit sympathy. Because we don't want to talk about the act, which was the whole reason for the trial. We want to talk about Albert Rodriguez, because look how poor this poor guy, you're going to hurt him? Why would you want to do that? That's mean. So I would submit, Your Honor, that affected greatly.
Was there testimony given about Albert's situation independent of anything he would have said?
As far as what his, you mean his...
Whether he was being supported by Joseph Rodriguez?
There wasn't any testimony, and that's another point that we bring out in the brief, is that there was no evidence whatsoever put down in front of this court that Joseph Rodriguez was paying Albert anything. And there's no evidence that Joseph Rodriguez, with the money that he had, was going to give any of it to Albert Rodriguez. So the question itself, the closing argument, was based on a false premise, which I would submit to this court based on Rinaldi, was completely irrelevant. And if I can present, I could defend, I believe, any punitive damage case if I'm just allowed to decide what evidence I put in front of the jury.
Or what implication you're allowed to make.
Or what implication I'm allowed
Which
to
really
make.
what happened here. That's the evidence.
Yeah, there wasn't evidence, but I submit that it's not, the answer to this is not to go back down and allow them to submit evidence, because that just creates a further diversion for the jury. The answer is, in this case, if you want to put on evidence about why he shouldn't be punished for the murder, that's great. But we're not going to go into a sideshow about this poor guy who needs some help, because that is going to confuse the jury. It's highly prejudicial. The other question I would ask is, if you look at what Albert actually said, which is in my statement of facts, how exactly does that support any theory of the defense, other than one they're not willing to state, except in closing argument? 10 or 15 years ago, they may have got along. Maybe they did, although I'm not sure that that's what Albert said, because it doesn't seem coherent. But if they did get along 10 or 15 years ago, then how does that negate the fact that he murdered her on June 26 or 27, 2007? I would submit it doesn't negate that at all. I would submit it's irrelevant. The good things that Joseph did in his life, and I'm sure he did good things, how is that relevant to the issue? It confuses the jury, and that was part of the fundamental error in this case.
You're coming to your 15-minute mark, so you do what you want with your 5 minutes, but I just wanted to give you the heads up.
Thank you, Your Honor. I'm going to reserve the balance of my time.
Good morning, Your Honors. Brad Donnelly on behalf of the defendant, Appellate Joseph Rodriguez. May it please the court. The issue today is whether or not the trial court abused its discretion when determining the motion for new trial and whether the court's denial of plaintiff's motion for new trial was an abuse of discretion.
Well, it really goes a little deeper than that, does it not? I mean, it really comes down to whether there was reversible error in the trial, whether the judge saw fit to grant a new trial or not.
Agreed, and that's the reason why we're here to talk a little bit about these facts of this case, and I'll try to respond to your questions that you previously asked plaintiff's counsel. Regarding Rinaldi, the issue is whether or not the evidence presented in the case goes to any mitigating circumstances or any circumstances that allowed or soften the culpability of the defendant's acts that can reduce a demand or an award of punitive damages.
Okay, so what did Albert contribute to that?
Albert contributed, well, what he talked about was in rebuttal to the plaintiff's witnesses in this case, who were Deborah Kosman and a neighbor, Sally Madalena. He offered evidence regarding the relationship between Joseph Rodriguez and his wife, which was brought up on direct examination of Deborah Kosman. He talked about the relationship between himself and his father, himself and his mother, as well as their financial assets in this case.
Well,
he also discussed...
This
Yes,
man
Your Honor.
was obviously, and it's undisputed that he was mentally disabled.
Oh, that is
It's pretty
disputed.
clear in the transcript that he did not really understand what was going on in this case.
Well, it's also not clear in the transcript
And
the
in
fact
terms
that...
of the financial situation, I mean, whatever he may have said or might have known was incredibly broad and vague, correct?
I believe it was broad, yes.
So how would a jury, number one, how would a jury, based on his testimony or any of the evidence in the record, know what Mr. Joseph Rodriguez's financial situation?
Well, that's a fine point, because in this case, plaintiff's counsel put on Deborah Kosman, the personal representative of the estate, for a brief 3 or 4 minutes on direct examination. Plaintiff's counsel could have brought up issues related to probate, could have brought up the will, could have brought up the beneficiaries of the estate to talk about who would benefit from an award of punitive
that's
damages.
not the question. The question is how does any of this contribute to an understanding of Joseph Rodriguez's finances? The estate is, what's in the estate is not his.
What I'm talking about is the fact that it could be some information provided to the jury based on plaintiff's case in chief discussing who was going to benefit from this award of punitive damages. Then it would be burden on plaintiff to show these financial assets. Now this is an interesting point, and I'll agree that this is
different than who has to pay it.
agreed. But the idea of the
So I think
financial...
what you're saying is there really wasn't any evidence regarding Joseph Rodriguez's finances.
No, I believe there was evidence regarding...
Well, then tell me what it was.
Okay, there was evidence from Deborah Kosman who talked about the estate owning half of the house,
The estate
and
is
that
not his.
and Joseph Rodriguez owned the other half
And
of
how
the
much was
estate.
the house worth? How much was owed on it?
There was a request, and I asked the question of Deborah Kosman, did she ever have an appraisal done on the house? She said no.
Okay, so now we don't know then how much the house
But we're aware that he has financial resources in the case law.
The thing is, though, is knowing somebody has financial resources, how does that help a jury determine how much would bankrupt the defendant?
The determination by the jury is not necessarily a mathematical equation as to how much would be enough or how much would bank.
But they would need to have some more information than just he has a house or a half interest in a house.
Well, again, back to the issue of financial resources, I believe that the case law out there talks about it makes sense for a plaintiff to want to put on evidence of the financial resources of a rich defendant, because then potentially the jury would award a larger amount. And then there's also case law that talks about a defendant, if the defendant was poor, they would want to put on evidence of their lack of wealth in order to keep a judgment low. This set of circumstances here is where the plaintiff didn't put on any evidence, admittedly, and he had the opportunity to put on evidence through the accountant of the defendant, but he chose not to. But he could have put that evidence on, but he didn't. Then is that a shifting of the burdens? Then does the defendant have to put on?
He started off with why, what did Albert contribute to this thing? And he said, well, he talked about the financial resources of Joseph Rodriguez. You know what? I think that's a fairly disingenuous statement.
If I respectfully, and I disagree that it's disingenuous, because the burden, the issue related to financial resources. If the plaintiff doesn't put on that evidence...
No. What did Albert Rodriguez contribute? You said financial resources. I'm not talking about what the plaintiff's burden was. Plaintiff objected to his testimony, wanted a voir dire. You're here, and I've asked you to justify basically what his role was in this trial.
His role was to discuss and to rebut the testimony brought by Deborah Kosman and Sally Madalena. He also discussed his relationship with his father, his relationship with his mother, and those are the types of mitigating circumstances that soften the culpability of the conduct.
In any of that testimony, did he say that he was being supported by his father?
No, he didn't.
Did anyone say that?
I don't believe they did. But I don't believe that that is necessary under the circumstances of this case.
Your argument in closing that somehow the sins of the father would be visited on the son.
That's a rhetorical question. The argument was...
It wasn't terribly rhetorical, was it? You
The
think
question-
everybody in the room didn't know what you were talking about?
The question that I was presenting to the jury was, the purposes of punitive damages are to punish and to deter. The question that I was asking the jury to consider in light of all the information that was provided to them in this trial is that if the purpose of punitive damages weren't going to punish the defendant who's already been punished and wasn't going to deter the defendant who's already been deterred, then what purpose would they serve? That was the relief in which I was trying to ask that question, saying, if punitive damages under the circumstances of this case do not fulfill their purpose, then who would be punished thereby? That's the question.
What does the sin of the father being visited on the son have to do with that?
Again, rhetorical questions are effective means of putting the evidence into a light favorable in closing argument for purposes of allowing...
I'm asking you what was the evidence that supported that. There's no evidence in this record that Albert Rodriguez was benefiting in any way financially from his relationship with Joseph Rodriguez.
Fair enough. But the issue is whether or not the punitive damages award would do their intended purpose, would actually punish the defendant. And the point that I was trying to make is that these punitive damages...
Fought pretty hard there to prevent it happening, did it not?
I'm sorry?
I mean, he was not laying down. He was trying to avoid this financial, punishment, was he not?
Mr. Rodriguez?
Yeah.
Yes, he was. Again, in closing...
There's a dearth of, no matter who has the burden, it strikes me there's a dearth of evidence. The estate should have highballed his worth, and there's nothing meaningful that I can sense. Joseph has an incentive to lowball his worth, and there's nothing.
And that, frankly, is trial strategy and part of the problem. Because plaintiff did not put on an accountant, although he had the accountant named on his witness list, who he could have put up there and spelled out exactly what Joseph Rodriguez's net worth was, to the dime if he wanted to, he didn't do that. But then the question is, how much evidence do I have to put on as a defendant in order to show that there is some financial assets without actually giving the jury the number to target? Is it the defendant's burden to put on that information in order to get that jury instruction, I think is what we're talking about. The case law, again, talks about the burden on the plaintiff if they want to get a high verdict, or the burden on the defendant if they want to get a low verdict. But I don't believe that the jury instructions that there's an obligation on the defendant to establish with precision the financial assets of the defendant in order to get the jury instruction that the award of punitive damages should not bankrupt the defendant. There's case law that talks about a defendant had a $9 an hour job and $1,000 in the bank account, and that was sufficient and required the trial court to give the instruction that punitive damages cannot bankrupt the defendant.
Here I have evidence that there's a house.
Mm-hmm.
I don't know what it's worth. I don't know what mortgage, if any. There's no meaningful information.
Well, there was information from Albert Rodriguez that they owned a business, they retired into Florida, there was a home, they went on vacations. Again, these were not quantified dollars and cents. It was not quantified dollars and cents. But it certainly gave the jury enough information to recognize that these folks had some money and that Joseph Rodriguez had some money. And in fact, plaintiff's counsel in his closing argument addressed all these issues vehemently and loudly to the jury, saying, this guy has money. He hired an army of attorneys, you know. He enjoys controlling the money that he has. Things like that that address the specific issue, saying that if they wanted to limit the award, then they should have put on that information. And I'm not disagreeing with that. What I'm saying is that he informed the jury in his argument as to the applicability of the law when it came to the financial resources, when it came to the amount of an award of punitive damages. What I'm saying is that it's the real issue, I believe, in the way that the courts have ruled on this issue is, frankly, it's a strategy that if you don't put on sufficient information for financial assets of the defendant, then what you forego is the ability to appeal an excessive verdict, because then you're saying that the excessive verdict isn't against the manifest weight of the evidence because there wasn't any evidence.
So
that's what you forfeit in making a trial strategy.
You put Albert on. You put Albert on in order to tell the jury that your client had money.
No, I put
You didn't have Albert testify to any indebtedness your client had, correct?
No, he did not testify to any indebtedness.
The purpose for you putting Albert on was to I don't know, give the jury some vague notion that your client had assets and money. They went on vacation.
Along with the testimony of Hal Arkin, who also testified that Hal Arkin, who was another defense attorney, or excuse me, another defense witness, who talked about being paid $300 a month to maintain the home. Right. But I also asked on examination of plaintiff Deborah Kosman, who has a fiduciary duty to take care of at least one half of the house, since the court has already split the asset in half, whether she had an appraisal done, whether she paid for any maintenance, whether she had any insurance on the home, whether she did an inventory.
What did that have to do with your client's financial resources?
What that had to do with the financial...
Frankly, what did any of that line of questioning about her conduct of the estate have to do with the issues in this trial?
Because she is the personal representative of the estate. She has brought the claim for punitive damages on behalf of the estate against the defendant. It goes to her credibility, it goes to her bias, it goes to her financial interest in the litigation.
How did the house appraised go to any of that?
It would be an asset of the defendant as well as an asset
She's
of the
not
estate.
under no obligation to appraise his half of the house, is she?
I'm not saying that she was.
I'm really having trouble understanding what the purpose of that. Well, actually, I think I do understand what the purpose of it, but I'm having a real hard time finding a justification for it.
For what, Your Honor?
For the examining her regarding her conduct of the estate.
It goes to the witness's credibility, her bias, her motive to be untruthful, as well as her personal financial interest in the outcome of the litigation. All of that is appropriate areas of questioning of a witness, especially on cross-examination. It helps to flesh out the case. It allows the jury to understand the issues of the case, to come to the truth-finding aspect of the case. And when plaintiff put Deborah Kosman on the stand, he only questioned her for a couple of minutes. I believe that was calculated to avoid some of these issues, because I took her deposition and asked these same questions in her deposition. And so I think it was a calculated attempt to minimize that issue. But the court allowed, on my direct examination of the plaintiff, because his direct examination was so limited, to go into these areas, again, to show the credibility, the bias of the witness, and the personal financial interest in the outcome of the case.
So if she hasn't done a very good job in, I suppose, your estimation of administering the state, this goes to her, what, credibility?
I would say so.
Okay.
The idea, Your Honor, and what I was trying to present to the jury is the only thing that she did in this case was to file a lawsuit seeking punitive damages.
Right, and what does that have to do with the issue in the case?
Whether or not to award punitive damages?
Yeah, it could be that claim in an estate might be the only asset in an estate. What does that have to do with it?
I don't believe a chosen action is necessarily an asset of the estate, but what it has to do with, it has to deal with the witness's credibility, okay, and her bias and her personal interest in the case. And I believe that the jury is entitled to hear that when they're making a determination whether or not to award punitive damages. And the issue regarding evidence and the admissibility of evidence is within the sound discretion of the trial court. The trial court is in the best position to see what's happening in the court.
Reviewable by this court.
I'm sorry, Your Honor?
Reviewable by this court, once we conclude that it was an abuse of discretion. Yes.
I apologize, I didn't understand what you
Yeah, it's in the judge's discretion until we decide whether it was an abuse of discretion.
That's true, but where there are, where reasonable minds can differ, that is within the judge's discretion, the trial court's discretion. It's only where the facts and circumstances are so clear and so one-sided and so uncontroverted where the trial court's decision can be overruled. Where there is conflicting evidence, and when that evidence is brought to a jury, it's the jury's responsibility to make the determination. And a jury verdict is frankly, the way that the case law reads, is not to be overturned, and especially in light of a motion for new trial, where the trial court also upholds the jury verdict and doesn't grant a motion for new trial. That also is an indication of the validity of the jury's decision in the case. Again, and then there's the harmless error statute that says that no judgment shall be set aside or reversed unless, in the opinion of the court in which application is made after examination of the entire case, it shall appear that the error complained of has resulted in a miscarriage of justice. There was no miscarriage of justice in this case. The case was presented to the jury. Plaintiff's counsel decided what evidence he was going to present. He tried to present evidence through deposition transcripts and other things like that that was excluded after a long argument. And so the trial strategy that he presented and that he brought to the trial is what we had to deal with. And we made our trial strategy determinations based on what was presented to the jury. There was no miscarriage of justice based on the evidence that was in fact presented to the court and to the jury. And the court's determination as to the admissibility of that evidence was appropriate and within his discretion. And again, regarding, I'll just touch briefly on closing argument. The law is well settled that unless the closing argument is highly prejudicial, inflammatory and improper statements will not result in a mistrial, a reversal, or a new trial. And again, if these statements were so highly prejudicial, plaintiff's counsel could have moved for a mistrial but didn't. Plaintiff's counsel could have asked for a curative instruction but didn't. Plaintiff's counsel only objected, and he was immediately overruled by the trial court. The trial court, sitting in the courtroom watching the proceedings, is in the best position to decide whether or not a statement...
The judge overruled the objection. How do you think he would have ruled on a motion for mistrial or a curative instruction?
I don't know.
I think I do.
Well, the issue was brought to him in a motion for new trial, and the court denied the motion for new trial.
The issue was first brought to him in an objection to the argument.
That's true, when it was overruled immediately by the trial court. Again, the trial court being in the best position to decide whether or not a statement made has some inflammatory aspect to it. In this case, the court immediately overruled that objection. And additionally, the way that plaintiff's counsel responded to that in his reply argument addressed all these same issues and was a strong second argument addressing these particular issues and explaining to the jury the basis of a punitive damages award, the basis of presenting the evidence of financial assets. He addressed those things. So if, to the extent that there was some level of I guess the right word would be prejudice, if there was some level of prejudice, it was alleviated by plaintiff's counsel's vehement argument at the closing of the case. Now, plaintiff didn't talk about the argument regarding the dismissal of Deborah Kosman's individual claim under the wrongful death statute. I don't know if the court wants to hear argument on that, but I'll touch it briefly, saying that the wrongful death statute does not permit an adult child who doesn't receive support to bring an individual claim under the Wrongful Death Act where there is a spouse. And in this case, at the time, and that determination is made at the moment of death, and at the moment of death of Wanda Rodriguez, she had a spouse. So the applicability of that law is straightforward, and the courts that have reviewed it, and have reviewed it since 1967, say that the determination of whether or not a spouse exists is made at the time of death. And under the circumstances of the case, she failed, plaintiff Deborah Kosman failed to state a cause of action under the wrongful death statute.
So you're suggesting that the subsequent conviction of your client for the murder had no bearing on that?
That's true.
So why couldn't he sue himself? Why couldn't he make a claim under the will? He's a surviving spouse, is he not?
Because of the application of the so-called Slayer statute, which
Right.
basically disinherits the killer from receiving any benefit from the decedent, which means that any right of survivorship is terminated, any contractual rights such as life insurance is terminated, any joint accounts, things like that are terminated.
The
They're
ability to
split.
inherit under a will.
And the ability to inherit under will, yes, Your Honor.
Right. So why can't we, the wrongful death statute is supposed to be liberally construed according to its introductory section.
Okay.
So if we were to examine that, the provision about this adult child in the absence of the surviving spouse, why wouldn't we read that into it and say, well, there was no surviving spouse here if we were supposed to give a liberal construction?
Well, again, the Slayer statute disinherits from taking from the decedent. However, it's not a forfeiture statute. The
Right.
Slayer still has the ability and has their own ownership interests. But the cases that have reviewed that particular statute, none of them have made a judicial exception. None of them have found circumstances, factual circumstances, that would justify making an exception to the clear language of the
None
Wrongful
of
Death
them have
Act.
involved the Slayer statute either, have they?
I'm not
Neither
certain
of you
about
have
that.
given us a case that's directly on point.
That would be true. I haven't found a case that's directly on point either. The problem, however,
The two statutes, reading together, as I understand it, and this may not be the right word, but no one gets a windfall because of the unfortunate death of this lady.
That's precisely right. And actually, I've written notes on that exact thing, that what would happen in this particular case is that a person who otherwise would not have a cause of action, but for the unfortunate demise through murder of a spouse, then all of a sudden would have a springing interest, if you will, of a cause of action only in those certain circumstances, only in those specific certain
If it's a wrongful
circumstances.
death case, it would be a cause of action against the person who murdered the spouse. I mean, I'm not sure that when one talks equity, one would necessarily call that a windfall.
Well, and I understand what you're saying, and I appreciate that. That's why it's
It's not like,
a
it's not
note,
like
but
she gets the right to sue a third party.
well, and the other
Situation.
aspect of it is because the Slayer is disinherited, because any rights that they would take inside or outside of testate, or contractually, those benefits or those monies and those resources all go to the estate of the decedent. So to the extent that the beneficiaries or the survivors, if you will, the beneficiaries of the estate, they are protected in the sense that the property that was once owned jointly is split, and then that property goes to the estate. The beneficiaries of the estate have a cause of action or have a right to claim under the estate. So there is a protection or a benefit to the beneficiaries under those circumstances.
Your time's up.
Thank you, Your Honor. Thank you, Your Honor. Thank you, Your Honor.
Very briefly, there's 2 points that I want to bring on rebuttal and then discuss the last argument. One point was, under the law as I understand it, that if a instruction is given to, or closing argument is given to the jury, and the trial counsel objects and the court sustains the objection, at that point, then the trial counsel is required to request a mistrial. Because if the trial court doesn't request a mistrial, trial counsel is then deemed by the appellate court to have made a strategic choice to not do that. Here, we have a jury trying to do the right thing. The defendant argues, do you want to punish Albert? Look at him. Look at this poor guy. You want to hurt him? You're going to hurt him? There's an objection, and the jury's all looking to the judge. What's he going to do? There's an objection. The judge overrules the objection. That's putting an exclamation point on what was said. So now the jury's thinking, well, he overruled it. I guess we're supposed to consider that. Do you want to punish him? I don't want to hurt this poor guy. So I would submit that requires a reversal by itself. Regarding the financial resources, as I discussed in the beginning as citing Rinaldi, is an affirmative defense. Let's assume they had $600,000 here. And think about, if somebody's murdered, what's that worth? What's it worth? You murder somebody, and they've got assets. How much is that worth? 20 million? I don't think that's enough if I'm a jury member. But if they want to argue, and they have a jury instruction saying you cannot, and that's the key, the submission of the jury instruction. They don't want to put down what he has, and they want the jury instruction, so they get it both ways. They want to affirmatively say, look, the guy has, assuming $600,000, therefore you can't financially bankrupt him. Well, you're likely to get a jury verdict, right? A jury verdict of something will give him $400 or $500. We're not going to financially bankrupt him. He's in prison. What does he need? Now, don't put on anything, and then give him the jury instruction. Again, this results in confusion of the jury. This is exactly the type of situation that all the district courts have said, this is a fundamental error and results in a miscarriage of justice. Argument 3, which I didn't touch on initially, but I do think is very relevant because as far as we've looked at, this is a case of first impression in front of this court. And what the Florida Supreme Court said...
Do you have any idea how much we like cases of first impression?
Actually, Your Honor, I do. I don't get to say that very often, but there is no case in point directly on this. And what the Florida Supreme Court said is, where possible, courts must give effect to all statutory provisions and construe related statutory provisions in harmony with one another. That's the overriding guide here. And so you have a situation where 732-8024 says any other acquisition of property or interest by the killer, any acquisition of interest, including a life estate and homestead property, shall be treated in accordance with the principles of this section. So I would respectfully disagree.
Yeah, but the problem is I mean, like devil's advocate both ways. The problem here is that we're talking about a cause of action for wrongful death, and he doesn't really acquire that cause of action having committed the cause the wrongful death himself, right?
Your Honor,
I mean, maybe if he had, well, never mind. But he is convicted of murdering his wife, and I joked a minute ago about suing himself. But I mean, I don't think he acquires a cause of action having committed the murder himself.
Your Honor, I thought the question was very good, because if you look at this from the statute, why doesn't he require a cause of action? Why not? Why can't he sue himself and get some money for himself? Assuming, now it's absurd, but the reason it's absurd is exactly the reason that the court should construe these sections of the statute together. Think of a policy perspective. The defendant says the legislature has not spoken. I submit that the legislature has spoken very clearly. They have said, we don't want him getting anything. The right to immunity, the immunity from a lawsuit, I would submit to this court, is an interest. He is not entitled to acquire that interest by the act of surviving the murder. And I also believe, Your Honor, that the legislature addressed this question. When you're looking at a statute, all the way back from when I was at law school, you can look at what it actually says, and I believe it says what we're advocating when you construe them together. What did the legislature intend? What did they mean? I think the intent is clear. Is that when you have somebody who murders their spouse, in that situation, that's the only situation we're asking. Then in that situation, because of the Slayer statute, then surviving children do has a cause of action because the surviving spouse is stopped from asserting that.
The Slayer statute operates as a forfeiture, correct?
That's one thing it operates on, yes, Your Honor. But
I'm just wondering if, from a policy standpoint, why isn't it something in need of a legislative fix to create a cause of action for a surviving child when the slayer has forfeited interest?
Your Honor, the position would be this, and I would argue that the legislature has spoken. The language that they used in 732-8024 was as expansive as they could make it. They used the word any other acquisition of interest. any interest at all. And literally what they're saying is, well, he survived. He's a surviving spouse. He murdered her. He survived. Therefore, you can't sue him. The acquiring of immunity is an interest. I believe the legislature had made it very clear that you don't get that interest when you murder somebody. And from a policy perspective, in adopting what the Florida Supreme Court has said, I believe is exactly what they said. Construe the statutes together. Don't ignore the Slayer statute, because it is a forfeiture. But I would submit that this language is not just a forfeiture.
Okay, your time is up.
Thank you, Your Honor.
Our next case is Henderson versus Stolley. Is Ms. Henderson here? Did she ever show?